Courts of Justice Subcommittee on Criminal Law will come to order. Please open the roll. Members, cast your attendance. All right, so we have 7 present. Close the roll. Excuse me, I just ate a little breakfast bar and it's right there. Excuse me. If I may, while I take this break, I just want to make sure that everyone who may be online at this time or in the audience is in part because it's a Friday afternoon and there's snow predicted for some of the members who will try to get home. So 2 things. One, that we have 2 bills that have been stricken from the docket, so I want to make sure that you're aware of that, and that is Converse Fowler, I believe that would be HB 1302, has been stricken from the docket. And then also Rasool's 1070 will go by for the day. So if you're on for those, they will not be heard today. Secondly, for the order, as members come in, I will be recognizing them first, despite the fact of how this is listed. And also for those who are testifying in the room, my habit is to find out how many are speaking for or against, and then split a block of time so that you can share that time, perhaps some of you wanting to tell us in more detail, particularly in this committee, personal impact of a particular crime or a bill that might be before us. But online, because of the number of speakers who have signed up on many of the bills, when we have that larger block of speakers, I will be limiting you to 1 minute rather than 2 minutes for those where we only have 2, no more than 3 speakers. Do we have a motion to strike? On that, I think, although it's at her request, thank you, Delegate Delaney, we have a motion.
Move to strike House Bill 1302 from the docket.
Been moved and seconded that at the patron's request, we strike HB 1302. Any discussion? All those in favor say aye.
Aye.
Opposed?
It's a recorded
Thank
vote.
you.
It's a recorded vote.
There we go. Please cast your vote. HB 1302 is stricken from the docket by a vote of 9-0. Okay, now the first presenter is, in fact, Delegate Converse Fowler. If you would please come forward on your other bill that is before us, which is HB 191.
Thank you, Madam Chair. I have an amendment in the nature of a substitute.
Move the amendment.
Second.
Been moved and seconded that we adopt the substitute. All those in favor say aye. Opposed? Aye. Please proceed.
Thank you, Madam Chair. HB 191 seeks to prevent minor victims of sex trafficking from being prosecuted for such offenses. I first heard about, this idea has been being worked on for quite a while, but I was recently at a church, Filipino church in my district, and a constituent brought up the issue, and it really is something that I wanted to try and bring forward and bring to attention. Madam Chair, we have received a lot of positive support for this bill and for getting Virginia aligned with many other states that are safe harbors for these young people. Madam Chair, I hope that is the will of the subcommittee to report favorably on this bill. And thank you very much to the committee.
Thank you. Are there any questions or comments? Seeing no one listed to speak, is there anyone in the audience who would like to speak in favor of HB 191? Is there anyone wishing to speak against HB 191? If you would all please come forward. Seeing no one. And online, however, I have a number of speakers. So again, on this, if you would limit yourself to 1 minute. And the first person who has signed up is Lindsay Gray from Safe House Project. Lindsay, please identify yourself. I don't see Lindsay Gray. Then the next speaker is Courtney Deslett, and from the Virginia Coalition Against Human Trafficking. Courtney online. The next one who is signed up is Sydney McCoy from Shared Hope International.
The room clerk is letting me know she's absent as well. She's absent as well.
Okay. The next one then is Patrick McKenna from Virginia Coalition Against Human Trafficking. Patrick. I think it's important, though, to know that these people did sign up as I give their organization. Fatma Mawahid from Hana Fatma Mawahid, speaking for herself. Sheba Williams, speaking for No Left Turns. Valerie Slater, speaking for Rise for Youth from NAACP. Valerie. And you have 2 minutes since the other speakers did not sign up.
Thank you, Madam Chair, members of the committee, and we thank the patron for bringing forward this bill. Delegate Watts, as you know, you have worked very hard with us on similar bills to ensure that individuals who are victims of sex trafficking are not prosecuted, and this bill goes even further, and we are so grateful that the patron has brought this bill. And so Rise for Youth and the Virginia State Conference in NAACP strongly support and urge the committee to please report this bill.
Thank you. And I see we have other speakers. If you could please identify yourself. This is Courtney Schwartz. You have 2 minutes. Please proceed.
Yes, hi, Madam Chair and members of the committee. Courtney Schwartz with the Virginia Sexual and Domestic Violence Action Alliance. We are very grateful to the delegate for bringing this forward. This bill is an important public safety measure as it will encourage victims to cooperate with investigations, and it will help to protect minors who are victims of sex trafficking. We strongly support this bill. Thank you very much.
Thank you. Seeing no one else wishing to speak, I do also have online with no position Nicole DeRose from Disability Law Center of Virginia. Nicole, are you online? I see she is not online. Before I turn to the patron for the final word, just to make sure we're all understanding, if council has any comment or walking through what happened in the substitute so that we understand whether there's any, what the significant difference is with the substitute.
Yes, Madam Chair, members of the subcommittee. The substitute really just clarifies the language. It references specifically that the minor shall not be subject to arrest. The original bill just said prosecution. And it adds language about being referred to social services and that the law enforcement officer, if they arrest the person when obviously the statute says you shall not, that they will not be liable for, they will be immune from prosecution. Excuse me, they would not be liable for false arrest. That language is in existing code under 18.2-251.03, which is our safe haven statute for overdoses and reporting instances of sexual violence. So if someone is experiencing overdose or sexual violence and they call for the police, they can't be arrested or prosecuted under that statute. So that's just mirroring the language that if we're going to say that this applies to minors in this instance for the qualifying offenses, it's just going to be parallel language.
Thank you. And I see our outside counsel is also nodding her head. Is there anything that you would add for context?
No, that's what Troy and I discussed and why we mirrored the statute.
Delegate Converse-Fowler, you have the final word.
Thank you, Madam Chair. The recommendations on the substitute were given to us from stakeholders that were going to testify. So I think we've met the concerns, but I do know this is an issue that's been ongoing and a work in progress. So I do hope the committee will report favorably on the bill. Thank you, Madam Chair.
Okay, we operate by motion. Is there any questions, discussion? Motion.
Second.
It's been moved and seconded that we report the substitute. Seeing no one else wishing to speak, please open the roll. Members, cast your vote to report with substitute. It passes by a vote of 10-0 unanimously. Congratulations.
Thank you, Madam Chair, and the committee.
All right, then the next person that I saw in order is, could you decide which one was in the room first or the first two? Please go ahead. You are next.
Thank you so much, Madam Chair. I have two bills before you, and I can start with 648 House Bill, if that's okay with the committee.
House Bill 648 is before us.
And I know this is courts and not education, but I did bring a handout. If I could just hand it to the committee. Just for a visual.
You'd hand it to.
Thank you. Okay, thank you so much. House Bill 648 seeks to address an increasing epidemic in the Commonwealth, an epidemic with significant consequences both for citizens, family, and the public at large, regardless of their age, through recreational misuse of nitrous oxide, also known as galaxy gas and whippets. Since 2010, misuse has been on the rise, and with the substantial rise of use has also been the substantial rise of harmful effects. This is a short-term high with long-term effects that keep people in a cycle of use. Nitrous oxide is a potent inhalant responsible for health risks like seizures, heart attack, paralysis, blood clots, brain damage, and death. The product exists for food preparation and culinary purposes, like whipped cream. However, loopholes in our code continue to allow something that is designed for industrial use or culinary purposes to be used, or perhaps a better word, abused, with devastating impacts, especially on young adults. Nitrous oxide is listed after cocaine as the third most common drug. It's relatively cheap, flavored with ingredients like pineapple and coconut, can be easily purchased, and needs additional regulation. As you can see from the handout I just showed you, that it's marketed to entice and glamorize a drug and addiction. This bill is very targeted. It seeks to address the negative consequences of galaxy gas in Section C that says when the intent is to intoxicate or excite, delivering specific results of a person of any age, then it should be illegal. And so we made sure to put those words in specifically because nitrous oxide does exist for dentists and for culinary purposes, but we want to ensure that we are regulating it for those that are being misused. Madam Chair and committee, I can stand up here and probably give you hours of testimony and stories. This bill was brought to me by a constituent because of a personal story and the need for regulation. And I see this is really where government works well, where it comes from constituents that are seeing a concern that want their government to act. So I would really love the opportunity for the folks to speak in support to be able to speak to you. Thank you.
Thank you. Are there any questions? I see that Delegate Williams. I recognize you first, Delegate, and then, okay, my list keeps on changing on me. In the order I have it, I'm going to first recognize Delegate Williams.
Yes, question for the patron.
Yes.
What did you just say? Nitrous is third?
Yes.
Can you repeat that and tell me who one, two, and three? What were you saying?
It's marijuana, cocaine, and then nitrous oxide.
And now I see Delegate Davis and then Delegate Schmidt. Delegate Davis.
Thank you, Madam Chair. I want to thank the patron for bringing this. This is a problem. I've represented many folks charged with DUI by using this, but by the time they get back to do any types of tests, it's out of their system and it cannot be detected. So thank you.
Thank you.
Delegate Schmidt.
Yes, thank you, Madam Chair. I have a question. Does your bill would this ban the sale of reusable whipped cream containers for the consumer?
Thank you. Chair Watts, no, it would not. And that's where specifically where we've put in this language, and I'm happy for council to also tap in here, but it says with the intent to intoxicate, inebriate, excite, stupefy, or dull the brain or nervous system for such a person. That's where the purpose has to be done specifically for that. And those were the proper words that we've seen come through to ensure that if you're using it, like that whip it piece for culinary purposes, you're not doing it to do those things. So it would exclude that culinary reasoning or food preparation reasoning.
So, Council, would you address that point, please?
Just with regard to the amendment is specifically, it was amended last year that you couldn't sell nitrous oxide to any person under the age of 18 for any purpose. This amendment would bar selling it to any person for any purpose. So then there is the clause 2 that lists ways that it could be sold, but I think for your question, Delegate, that intent element is not required for the sale. So it's sale for any purpose for any person. That's the change to the statute. It was under 18, now it's for any person for any purpose. It's illegal, currently it's illegal to use any of these substances to get that intent, to get that high. That was always the law. This would now bar it for any purpose, any sale, unless it's with one of these carve-outs, which arguably the carve-out that you recommended may not be covered or allowed based on my reading of the language of the statute.
Delegate, continue, please.
Yeah, a follow-up question. I mean, this is particular for the section that we were just referencing, D2, it specifically says it shall not apply if you're solely engaged in a business of selling and distributing catering supplies, food processing, that sort of thing. I don't mean to be, I understand your concern with this, but, we're also talking about businesses, individuals that don't just use this product that are not in catering or professional services. These are, home used by home consumers. You can buy them, to use for reusable rather than one-time use, whipped cream, other things like that. So just wondering if that also is getting scooped up in the ban.
Madam Chair, I think that's where, but if you can still buy those things as long as you're not using it specifically to alter psychological and your human excitement or, as it says in here, inebriate yourself in using those. That's where the delineation takes place. And we did work with this language too, on the other side, to make sure that it would probably hopefully pass muster in terms of the language that you're using, so that is carved out. So you can use all of those things for culinary purposes still. That is not a problem because you're not doing it to induce yourself into inebriation.
So I need to go through this with counsel myself. So what we are talking about here when we're talking about subsection D is it's unlawful to sell, distribute, offer to sell, etc. And it says then this subsection 2 under that, it doesn't apply to the following things that are regularly used in food preparation.
So we have to
excuse me, ma'am.
I'm sorry.
Thank you, ma'am. Please.
Sorry.
Thank you. Please, when you are recognized, then you speak through the chair. But this chair was asking a question of counsel. Thank you.
My apologies.
So again, what I'm trying to follow how this is structured. So now we're talking about, again, to repeat myself, subsection D, it says it's unlawful to sell. And then it says this subsection shall not apply to anything that's sold for, again, commercial preparation. So that is the selling part. So we still have the situation that while this is only the selling part, we go back up to C, where it says that no matter how you obtained it, anybody who entices someone to smell or inhale is now guilty of the offense. But it's not the person who's smelling or inhaling. It's only the person who's enticing them to smell or inhale. Is that correct?
Thank you, Madam Chair. It's actually both, because if you look at subsection B, that criminalizes the person who's actually using it for that purpose. Subsection, what would be C, is the person who's encouraging someone else to use it. So both are illegal. One's a class one.
B is the person can't do it, and C is you can't entice a person to do it. Correct. Thank you very much for that clarification. So now I come back to, we struggled through this last year for minors. And just 1 year later, we're back applying it broadly. Why?
So when hearing from constituents on this, it's a true drug that has significant consequences. And so when you do inhale, we're seeing the effects of it be very harmful and drug-like. So it should be, regardless of age, not be used.
If I may follow up with additional questions. So what you're telling me in this last year, in this last 11 months, you have no incidents where adults are heavy. It's even more of a problem that we recognize. It's just you're relitigating last year's action by saying we didn't go far enough. We'll only limit the offense to minors.
It would have been I think it was a stair-step approach, just trying to make sure we were getting things on the books to cover it, but realizing maybe we should go farther. So that's where my bill, just from my constituents, it truly came from my constituents to say, we see this, but it's not far enough because there's still so many prevalent issues.
Thank you.
Thank you.
Delegate Davis, did you wish to be recognized, please?
Thank you, Madam Chair. I just have a question for legal. Do you see any unintended consequences from this bill?
The only thing in the notes that I had, because previously it was just illegal to sell it to people under the age of 18 for any purpose. It did include this carve out. But what the concern I had with regard to making it illegal to sell to anyone for any purpose except for these carve-outs is because it says solely engaged in the business. It seems like if people had part-time employment or something like that, that they were selling equipment or something part-time, that may now be illegal for them to do that if that wasn't their sole business, if there's a part-time employment, things like that. That's the concern, is do these carve-outs cover everyone who would be using it or selling it legitimately, I guess is the concern.
If I could also follow up on Council's response. So thank you for that additional clarification. So last year, it was illegal for anybody to entice, anybody to inhale, and the only thing that was limited for minors was you can't sell it to them. But we already have the offense of nobody can inhale it, nobody can entice someone to inhale it across all age ranges.
That's correct. That was always the law.
So yes. The only bill before us is whether or not you can sell to someone who is under age 18 these products that are typically used for commercial purposes.
No, the bill before us is making it illegal for anyone to sell it to anyone of any age for any purpose except for those carve-outs in Section 2.
Thank you.
Yes.
Then, if I may, if there are I see no one else. Coulson, you are recognized, followed by Davis. Coulson?
Thank you, Chair Watts. I feel like Council just said it pretty eloquently. It's not an issue with the intent, I think, of what you want the bill, but what this is actually doing is making it so that nobody in the Commonwealth would be able to go to like a commercial establishment like a Walmart and buy anything that has a canister, and you use them sometimes for like whipped cream or nail polish remover. We had this debate last year. We decided that for kids, we want retail establishments to pay attention when a kid is buying those. But this, as I'm reading it, the only exception is if you're solely a catering business. So Walmarts would have issues with this, and it's too broad. It's not an issue with what you're trying to do. It's just too broad. That's too broad. There's reasonable and practical uses for that, and it would be hard to enforce this, if that makes sense.
Counsel?
Yes, and Delegate, yes, it would the only carve-outs for sale would be the ones in Section 2, and that includes any person or establishment that is solely engaged in the business of selling or distributing catering supplies, food processing equipment, or compressed gases for industrial or medical use or a healthcare provider. Arguably, if they are not solely engaged in that business, then yes, they would be barred under this language. That's how I read the plain text of the statute.
Thank you. Delegate Davis.
Thank you, Madam Chair. Just another question for council. Would you have a recommendation on how to amend this to deal with those concerns of Delegate Carlson?
I don't like whipped cream that much, but there's no reason why people might buy nail polish.
Can I ask a question, Madam Chair, at appropriate time?
Is there any, Delegate Carlson has indicated that her question the answer stands that it is. Did you want to pursue then an amendment?
I would like to ask council if she has a recommendation on an amendment that would deal with those concerns.
So potentially, and I'm not the one who normally writes it, but I think solely engaged, I think you would have to eliminate solely, that it would apply to other businesses that are not solely engaged. The other thing, when I was researching yesterday about nitrous oxide, potentially industrial or medical would not necessarily cover. I think it's used in laboratories. I don't know if all of those are medical. So that's the problem. I'm not sure of every use and if people are selling it for that use. Labs came up a lot in my research. So I definitely solely would check off that box that's of concern based on the language. But the carve-outs that there might be other uses that people are selling it for, if they're providing this and it's not based on one of these carve-outs, then I have concerns. I'm not just sure of all the uses of nitrous oxide that are legitimate.
Thank you.
Thank you. Now I believe we are ready for testimony. Anyone in the room wishing to speak for HB 648, would you please all come forward? Seeing no one, anyone wishing to speak against I'm sorry. Yes, 2 people. If you could just split 3 minutes, please.
My name is Nicholas Harkness. This is my mother, Doris Harkness. I'm a lifelong Virginian. My family moved here in 1988 to give, my mom came here to give her children a better life, and you guys all have an opportunity to do the same thing today. My experience with nitrous oxide has only been in the last 8 months. I've been hospitalized twice. It is a nerve agent. The issue with what was just being said about the distribution of this product is people aren't getting it at Restaurant Depot. This product is commercially sold to anybody at tobacco and vape stores. So every single product that's offered by these businesses in the state of Virginia is meant to be inhaled, except for this. People are going to a tobacco store to buy something to take home and make whipped cream. People have died outside of vape stores by going in and out. There's no regulation whatsoever. And all the times I've ever purchased it, nobody's ever asked me for an identification. I've never had to show an ID. I was in Bon Secours medical system twice under the care of their neurological team, and they had to defer to the MCV poison control department, because that's who has expertise on it. It is a poison nerve agent, just like Agent Orange, or if you inhaled Raid, insect repellent. I had to learn to walk again. I woke up one day and could not stand and was in a catatonic state and had to be taken to a vehicle by my brother, who fortunately is strong enough to move a 260-pound man. My organ function became so poor from intermittent use that I have gained and lost 100 pounds. It is by the grace of God that I can even stand and walk in front of this podium to give this testimony today. I spent 7 days under the care. They took me and put me in a wing of the St. Francis Hospital that is basically for people who have viruses that they don't know how to treat. There is zero recognition as a controlled or uncontrolled. I've talked to the Department of Health and Human Services. I've tried to talk to the police. And no action can be taken to even do any research on behalf of the constituents of the Commonwealth, because it's not mentioned anywhere. And it's destroyed my life. It's cost me a marriage. My family, luckily enough, I work with my mother, and she's my boss, and we have an industrial business. We sell to industrial, and even so, we shouldn't be licensed. If a dentist office wants to use nitrous oxide for anesthesia purposes, and they've gone through all the proper channels to be able to distribute that to a human being and gone through all the regulatory issues that come along with that, I don't see that as a problem. That's in a supervised, regulated, professional, medical situation. But the only medical situation it's created in my life as a private citizen has been dealing with neurological issues. As I stand here today, it wouldn't matter whether my hands were in my pockets or on this podium. I cannot feel my hands. The bottoms of my feet feel like I'm standing on pins and needles.
I have to now count the testimony, but thank you for those details. I truly appreciate it.
I appreciate your time. Thank you so much.
Is there anyone, I already asked, now I'm asking, is anyone wishing to speak against the bill? This would be against 648. 2 minutes max.
Good afternoon, Brad Haywood with Justice Forward, Virginia. There's been a tendency, it's now a 50-year-old tendency in the United States, that when we see an issue with a public health problem like substance abuse, that we want to solve it with punishment. And the problem with that, I think, has become evident through the conversation that this subcommittee had this afternoon, which is that we end up with rules and laws that don't punish they don't accomplish the objective we're attempting to accomplish. This bill, as drafted, would penalize people who don't have this intent. It would also penalize people who don't have any substance use disorder. The conversation that should be had with this, with everyone, especially people who are suffering and have suffered with substance use disorder, is how do we get them help? And that is what we don't talk about enough. We don't talk about funding our broken behavioral health infrastructure, about funding treatment programs, about detox facilities. And that's really what helps people like this gentleman who spoke this afternoon so eloquently. So we do speak in opposition to the bill, but we speak very much in favor of people struggling with substance use disorder and solutions for their problems. Thank you.
Thank you. Now turning to those who have signed up online, I have 4 speakers who have signed up. Jerry Gray Benedy.
Hi, good afternoon, Madam Chair and members of the committee. Thank you for the opportunity to speak. I want to thank the patron for bringing forth the bill. I worked with her on this. And my name is Jerry Gray Benedy. I'm here for strong support of Bill 648. It does protect Virginians by banning the distribution of the nitrous oxide products that are being sold for recreational use under the false label of culinary use in our vape stores all across the Commonwealth. In August of 2025, my 29-year-old son nearly died from nitrous oxide poisoning. This is a legal product anyone can buy in unlimited quantities at vape and smoke shops across the Commonwealth of Virginia. Because it's legal and sold alongside vapes, many people assume it's harmless. Well, it's not. It is immediately and highly addictive. Within just a couple months, my son developed neuropathy. Within 8 short months, he had massive blood clots in his legs, lungs, and a 3-centimeter clot in his heart. This did not take years. It took 8 short months. Manufacturers are hiding behind the phrase for culinary use only and do not inhale on their products. But the label is misleading and it's deceptive. These products are sold all across the Commonwealth in every corner on all these vape stores, and then inside the vape stores, they're showing them how to inhale them. I don't know a single baker or a chef that is going to the vape shops to buy a 3,000-gram tank of nitrous oxide in kiwi, strawberry, and fruit punch. While my son survived this, I have spoken with parents across Virginia, a woman last week whose daughter died 14 months ago at the age of 29 outside a smoke shop.
Could you please wrap up, ma'am?
This poison took their lives. This bill protects Virginians. It is a medical epidemic, and a silent one at that. This will help to close the dangerous loopholes and protect Virginians from real preventable harm.
Thank you for
Legal doesn't mean.
Thank you. Our next speaker is Jessica Dezara.
Yes, Desar, thank you. Madam Chair and members of the committee, my 37-year-old brother, an active, healthy, and successful small business owner, nearly lost his life due to nitrous oxide use, a legal product that is not only easily accessible, but also widely marketed in vape shops across Virginia. This is not just a youth issue. Adults are also being harmed, which is why the broader scope of this bill is so important. Nitrous oxide influence is virtually undetectable, making it even more dangerous. When you're in situations such as driving under the influence, the use of nitrous is difficult to verify, yet the effects and threat to others is just as serious. The more obvious effects of nitrous usually wear off within 5 to 10 minutes, and generally it does not stay in your system longer than 1 hour. I have personally witnessed nitrous oxide use cause reckless behavior, extreme changes in personality, anger, paranoia, hallucinations, and seizures. The lasting medical effects of nitrous oxide on the body are often not traceable until it is much too late, and it happens fast. In my personal experience between EMTs and ER visits, his vitals were perfectly fine at the onset, but no issues were detected by medical professionals. However, within days, the effects of the resulting B12 deficiency set in and caused life-threatening neuropathy. He lost his ability to walk and use his hands. It took nearly 7 months for my brother to be able to walk again independently. And that was with the extensive therapy that is unfortunately not easily accessible to everyone. This bill closes a dangerous loophole in the law allowing the distribution of nitrous oxide and harming Virginians. I hope that you will support this. Thank you.
Thank you. We also have signed up Ms. with no position, Nicole DeRose from Disability Law Center. I do not see that she's online. I am going to suspend action on this bill and also the one that follows. Delegate Kent, you have a bill that follows that is HB 875 that's similar to this, but it deals with Keratom. And Keratom is on the Consumer Protection Act. And I already had problems about whether or not that was properly before us. And as I'm hearing this testimony, I have the same concerns about whether this belongs under the Consumer Protection Act and how we actually deal with it, or whether we can carve out the places which are indicated that are selling it as something that would give a special feeling, vape shops. May I also disclose, I was in the dentist office. I know the dentist very well. I was given nitrous oxide, and I swear you, he was going to kill me. So I know that the nitrous oxide has a different effect than just addictive. So with all of this and how do we detect these products, all of that long explanation, I would like to suspend action on both of these bills today. We'll take them by, and I will try to determine how we can best hear them before the proper committee and perhaps with additional ways in which we can focus on what the problem is. I thank you, Council. Council asks that you offer that you request that we adopt your substitute so that it is properly before the body and is online.
Yes, please. Thank you for that.
Madam Chair, is that a substitute for House Bill 875?
It's 875.
Okay, I'll move the substitute.
Second.
It's been moved and seconded that we adopt the substitute for HB 875. All those in favor say aye.
Aye.
Opposed? Thank you. And now, again, thank you all who have testified. However this goes forward, that may or may not be part of the, rush of the last days of crossover, but your testimony has been most helpful. Thank you all from both sides of the aisle as well.
Thank you. We want it to be right, so I appreciate that. Thank you.
And now before us is, please come forward, excuse me, while I get the right bill in front of me. And if you'll identify the bill, that will be even more efficient.
HB 290.
Thank you.
You're welcome.
Please proceed.
Yes, ma'am. Thank you, Madam Chair and committee members. I am presenting HB 290. This has been presented and passed fully out of the Education Committee, but has been referred to you. And basically what this bill is doing is requiring any person who knowingly makes a false statement concerning the residency of a child in a particular school division or school attendance zone for the purpose of avoiding tuition charges or enrollment in school outside of their attendance zone. If they are misleading, they are no longer going to be charged a Class 4 misdemeanor. This bill downsizes it, downgrades it to a civil penalty. There's still a fine attached. So if you still do this act, you are still required to pay up to $250 to the school that you have wrongfully misled. But we are not criminalizing that action. So that is the intent of this bill.
And this is why the bill is before us. It did pass education unanimously as a policy, but it is before us as to whether or not it is appropriate to no longer make it a criminal act. Same penalty of $250 plus tuition penalties.
The original, Madam Chair, the original has always been up to $250, and that is staying. We're not touching the penalty fine whatsoever. We are simply just decriminalizing the charge.
Are there any other questions of the patron? Is there anyone here wishing to speak in favor of HB 290? Please come forward. I see two speakers. If you can split 3 minutes, thank you.
Good afternoon, Madam Chair, members of the committee. Sean Winetto speaking on behalf of the Humanization Project. We thank Delegate Anderson for bringing the bill forward. We did ask for this bill. We don't believe that we need to criminalize parents who are seeking a better opportunity for their children. Again, the same penalty staying in place to preserve a penalty for the behavior. However, there's all sorts of consequences, collateral consequences that come with a misdemeanor conviction. Simply going on a school field trip could even be prohibited with the existing penalty. So we don't want to punish parents in that manner. Again, the accountability is still there, but we want to try to eliminate some of the collateral consequences that come with this conviction. So we do support the bill and ask that you report it out. Thank you.
Thank you.
Afternoon, Madam Chair. Ben Knotts with Americans for Prosperity. We endorse this legislation. We thank the delegate for carrying it. I think it's a good opportunity for parents that are just trying to find a better option for their kids. We shouldn't treat them as criminals. We should work with them and try and figure out the best outcomes. And I will be quiet. Thank you.
Thank you. Is there anyone in the room wishing to speak in opposition to HB 290? Seeing no one online, we have two speakers speaking for. First is Dr. Mahone-Haft. Doctor?
Yes. Thank you, Chair Watts and members of the committee. Taj Manham, not for the Humanization Project today as a member of New River Valley Reentry Council and just as a parent. We don't need to criminalize. It's not a great decision to do this, but it's not a reason to make sure that people are not able to do things that they're trying to do to help their kids, like go on field trips or be able to have jobs. And if all you're doing is trying to help your family, criminalizing that is not the solution. So we appreciate Delegate Anderson bringing this, and we hope that the committee will pass it. Thank you.
Thank you. And we also have Valerie Slater from Rise for Youth and NAACP.
Thank you, Madam Chair. Yes, Valerie Slater, Rise for Youth and Virginia State Conference, NAACP. And we thank the patron for bringing this bill because HB 290, it represents an important step toward a more proportionate and appropriate response by eliminating that criminal penalty. And the civil penalty, while it may still cause some angst for families, at least there is still some level of accountability, especially when what we know is happening is parents are looking for a better way forward for their children. And so again, we thank the patron for bringing the bill, and we urge committee to report this.
Thank you. Seeing no one else wishing to speak, before I turn to the patron for the final word, Delegate Davis.
Thank you, Madam Chair. Question for the patron. what, with a Class 4 conviction, give me some examples of how that would prevent somebody from going on a field trip. Does it prevent somebody from going on a field trip, a Class 4?
Madam Chair, to answer the delegate, so it would depend on the school division, and some policies could be put in place at the local level that could hinder individuals from participating in different things. But it's the fact, too, beyond participation, we are putting basically a criminal mark on a parent for simply trying to do best by their parent. And at the end of the day, I don't think that is the right path forward.
Thank you.
Thank you. Seeing no one else wish to speak, you have the final word before action.
No, I appreciate your consideration, and I think this is a really good move forward to, be on the side of parents.
Is there any comment from council? Anybody wishing to speak? We operate by motion. It's been moved and seconded that we report HB 290. Clerk, any discussion? Please open the roll. Members, cast your vote. HB 290 reports by a vote of 8-2. Thank you, Delegate Anderson. And then the next speaker in the room is Delegate Cohn. You have before us, excuse me, I always have this problem with too much paper, and it's my fault, not the fact that I don't need the paper.
459, if that helps.
Thank you so much. Delegate Simon, please proceed. Sorry for the misidentification.
It's all right. Good afternoon, Friday afternoon. House Bill 459 would prohibit law enforcement from disclosing public information of victims of hate crime to the public unless the extent of the disclosure is 1, the site of the crime, 2, required by law, 3, necessary for law enforcement purposes, and 4, permitted by the court for good use. Virginia law already prohibits the disclosure of the names of victims of sexual assault, sexual abuse, and family abuse crimes. This would add the same protections for victims of hate crimes, of which only 1/3 are reported. Victims of a hate crime often do not report these crimes for several reasons. They prefer to keep certain aspects of their life confidential. They may not want an employer or coworker to know their sexuality, ethnicity, or national origin. Many do not want to report hate crimes for fear of second victimization or being targeted again after having their identity revealed for the same reason they were targeted in the first place. And I just want to say on a personal note, this bill was brought to me by a high school student in Virginia Beach who did a lot of extensive research and wanted to find out why hate crimes were so underreported. And particularly, we have some states, we happen to be one of them, with some low instances of reporting. And so this was his answer. So I want to do right by him and give him the full credit for coming up with the idea of using the same mechanism that we use to protect other victims and including hate crimes.
Thank you, Delegate Cohen. Are there any questions of the delegate? Delegate Davis.
Thank you, Madam Chair. I have a question for council. Again, same question as a few minutes ago. Do you see any unintended consequences with this bill?
No, based on the fact that it's already a carve out for victims of sexual abuse, this would just be the same. I understand the reasoning behind it, and like we do in sexual assault cases or juveniles, they would just be listed in an appellate opinion with their initials. Otherwise, it still says required by law, so if it's required to be disclosed in discovery, they would still have to comply with those things.
Thank you.
Thank you. Seeing no further questions, is there anyone in the room wishing to speak for HB 459? Anyone wishing to speak in opposition? Let us turn then to those who have signed up online. We have 2 who have signed up. One is for, Valerie Slater, Rise for Youth, and Valerie.
Yes, Valerie Slater, Rise for Youth and Virginia State Conference NAACP, and we strongly support this bill. We've got to protect individuals who are victims of hate crimes from further victimization, and this is one way we can absolutely do that. We urge you to also report this bill.
Thank you. And then we also have signed up is Nicole DeRose from the Disability Law Center. And then also from the Office of the Executive Secretary, Eileen Londecker, are you with us? Is there anything you'd like to share? Not seeing Eileen with us at this time. Are there any questions of the patron before she has the final word? Proceed, Delegate Cohen.
Thank you so much. Just, as a note, I know that most people are aware that hate crimes went up about 30% in 2024, and now we've continued in 2025 to see an even greater rise. And so I think this couldn't be more timely just to make sure that victims are reporting incidences and are able to get some sort of peace, hopefully, and closure when these horrible things happen to them.
Thank you. Move to report. It's been moved and seconded that we report HB 459. Any discussion? Clerk, please open the roll. Members, cast your vote. HB 459, please close the roll. HB 459 has been reported unanimously 10-0. Thank you.
Thank you very much.
Now I'm still looking for my agenda. So the next one is Delegate Simon. Delegate Simon, you have before us, is that HB 43?
Thank you, Delegate Watts. That's right, HB 43, Madam Chairman.
Please proceed.
So this bill should look familiar to you all. We saw this bill 2 years ago, but we've added something to it. So this bill would abolish the common law crime of suicide in Virginia. And just to briefly explain why that's important. So Virginia, there's no law against suicide in Virginia on the books and the code, but we do adopt the common law early on in Section 1. So what's happened is that folks that die by suicide, their families are often denied benefits, denied opportunity to enroll in certain programs and things because of an Attorney General's opinion that says that death by suicide is the result of a criminal act. And so whenever sometimes there are all kinds of benefits that are barred to someone whose death was the result of their own criminal act. And so what this bill sort of seeks to do on that basis is remove the criminal act by explicitly abolishing the common law crime of suicide. There's also a certain stigma that goes with that. You may have heard, if you guys got some of the emails, I know I was copied on some of the emails that went out to the committee members from folks who've lost family members to a suicide. Just the fact that they're labeled as a criminal is a painful situation for them and something that continues to prevent their own sort of healing process. So what this bill does is again abolishes that crime. What's different about this is that when we got over to the Senate 2 years ago, we added a delayed enactment date. And now, so we've got that delayed enactment date. Obviously, it's different. It's delayed a little bit further. And then language in here that requires the Bureau of Insurance to review the effects and implications of the abolishing the common law crime of suicide on insurance policies and report back to the General Assembly at least prior to the pre-filing deadline for the next session. So if there are any sort of unintended consequences or any cleanup that needs to be done, the bill that we'd have another legislative session to make those changes before the bill became effective the following July. So I thought that was actually a fairly sensible way to handle that particular problem. So we've incorporated that sort of proactively in this version of the bill. So that's what the bill does. It's passed the House in various forms several times. I think we got it through the Senate and it was vetoed by the governor. If you read the governor's veto statement, and I don't necessarily encourage you to, but you won't learn a lot from it. You may be dumber because of it. But anyway, it confused this issue with some other things. And so this has nothing to do with medical aid in dying. This has nothing to do with assisted suicide or anything like that. This is simply abolishing a common law crime going forward. So thank you, Madam Chair. That's the bill.
Thank you, Delegate Simon. I see we have two people, Delegate Davis.
Thank you, Madam Chair. Question for the patron. Will this, if this is done, will this require the insurance companies, if they had life insurance, to pay now?
So it will depend on the different policies, and that's again what we have the Bureau of Insurance looking at is to see how broad those implications would be. Would they apply retroactively for folks that had been denied previously? So that's the sort of stuff we want the Bureau of Insurance to look at to see if they feel like we need sort of further refinements to the bill.
Delegate Carlson.
Thank you, Chair Watts. Question for the patron. I don't mean to be throwing you a random loophole, but this is just something I experienced. When you decriminalize suicide files, The police generally are involved in that initial investigation. Have you put any thought, or is there any caveat for FOIA? When we last messed with FOIA, I ended up getting requests to review past suicide photos just from like the morbid kind of true crime conspiracy people. And is this going to affect that at all? Because police will have those photos, then they won't be classified as an ongoing or a criminal investigation, and then they're subject to discretionary release. And I'm just, I guess, worried about that.
Yeah, so I mean, that's a question. It's certainly something that we could, in that 1-year delayed enactment, could certainly look at that issue as well with the FOIA Council, which I chair. But yeah, I do think that there's positives and negatives, right? There was discussion in years past about how these deaths would be investigated if it's not a criminal act. Right now, they invest, like as you know, they invest them all as a criminal investigation, because it's either the crime of suicide or the crime of homicide, and that's how they do their death investigations. We've had a conversation before. I think the consensus is if you want to do a criminal investigation, you need to have some sort of probable cause to believe that a crime has been committed, the crime of murder. And so we don't necessarily want to grant warrants to folks or make exceptions to allow people to investigate this, even though it's not a crime. But the specific issue that you raise of what becomes the status of those investigative files, will they retain their status because it was a crime at the time as criminal investigative files, which I think is probably the answer. But I'm happy to look at that issue in the year in between the passage and enactment.
Chair Watts, if I can
Delegate Coulson.
Thank you. That's all. I mean, you're on the FOIA Council. If we could just, I think it was an unintentional little loophole that happened the last time we messed with investigative things. I got a lot of requests as a city or at the city's office for random photos, so I would like to protect that. So have a look out for it.
Okay.
Delegate Williams.
Yes, Madam Chair. I guess it's just speaking to the bill. My preference is always to study something before we change the law. So I would prefer the Bureau look at it first, get back to us, then look at it more. But I understand your, route.
Thank you.
I'm making a comment from the chair. Oftentimes, unless you have the focus of the change in the law, the study does not go forward, and it also doesn't focus on if this became law, specifically what ramifications would there be, and that's why we tend to do it it's appropriate on occasion. Are there other comments?
Council.
Seeing no one wishing to speak, may I hear then from those in the audience who wish to speak in favor of House Bill 43, if you would all come forward. Seeing no one, those who wish to speak in opposition to HB 43, please come forward. I have two individuals, 3 minutes total, please.
Madam Chair, members of the committee, my name is Dr. Michael Huffman. I'm the Executive Director and Teacher of Constitutional Law with the Virginia Assembly of Independent Baptists. And HB 43 is not harmless. It strips away the common law principle that suicide is a wrong that a state has a duty to prevent. That principle is the backbone of emergency intervention and mental health protection. Abolishing this sends the message that life is disposable. And on the note of the insurance payout, if my memory recalls correctly, and I may have missed something, I believe 38.2-3106 of the Virginia Code expressly forbids an insurance company not to pay out benefits except for two clauses. Number one, if there's a suicide clause in the policy, and number two, if the suicide occurs within 2 years of the policy. Barring those two things, I believe 38.2-3106 forbids an insurance company from paying out even with common law on our books. Thank you very much.
Thank you.
Madam Chairwoman, Todd Gackey on behalf of the Family Foundation. And actually, I'll say that I appreciate that there's a delayed enactment and that there's some looking into this issue. I think based on some of the questions, I would agree that I think we're kind of getting the cart, the cart ahead of the horse. There we go. With that said, we still have reservations about this, and it's just because of our belief that look, killing is bad, whether it's someone else or your own life. And it's okay that we can state that in law. No one's going to be penalized for this. My heart goes out to those. This is a tragic scenario. My sons went through public school every single year that they were in school. Someone took their life. So I don't diminish that. But at the same time, it's okay to say that something is wrong. I think there's reason for us to have some further investigation and take a look at this. So I appreciate that effort. I would like to see it done before we take up the bill and pass it. But I've heard your comments, Madam Chairwoman, and thank you for the time.
Thank you. Seeing no one else wish to speak online, we have 3 people who have signed up to speak for it. First, Nicole DeRose from the Disability Law Center. Nicole.
Good afternoon, Madam Chair and members of the committee. My name is Nicole DeRose, and I'm a disability rights advocate for Disability Law Center of Virginia. Next time I've noted not to put no position if I don't want to speak on a bill, but today we are in support of HB 43. People are not going to not harm themselves because it's against the law, but we do believe that passing this bill would be a step in the right direction for destigmatizing mental health and hopefully encourage more people to seek services. So because of that, we are in support of HB 43 and hopefully it will pass. Thank you.
Thank you. The next speaker is Andrea Walker. Andrea? The next speaker then is Rita Utz from the Mental Health Virginia.
Thank you, Madam Chair, members of the committee. My name is Rita Utz, and I am representing Mental Health Virginia today as their acting executive director. We continue to support this effort as in years past. So we speak primarily from our deep commitment to destigmatization surrounding suicide, mental illness, and mental health concerns. We want to be sure we're honoring the memory of individuals as well as supporting their families. Our work supports individuals and their families in prevention, intervention, and postvention. With this, we want to be sure our policies support practices that guide people towards resources and treatment. Stigmatizing and vilifying these experiences may discourage people from seeking out these things, and we want to make sure that that is not continued.
Thank you, Ms. Utz.
Thank you.
Thank you. And then we also have online, again, from the Office of the Executive Secretary, Eileen Longnecker. Is there anything that you would share with us about the bill?
Thank you, Madam Chair. We have no position. I just wanted to be available for amendments or any questions. Thank you.
Are there any questions, the Office of the Secretary? Are there any comments from council?
Yes, Madam Chair. Just one, looking at the bill, it's a small technical edit issue. Because we do want the study to go forward while this bill is working, we need to amend the second enactment clause to say that the provisions of the first enactment of this act shall become effective July 1, 2027, because if this is reported, goes to the floor, gets passed, gets signed by the governor, then it would have the force of law, meaning that the Bureau of Insurance could then conduct the study that we're saying. So I just need to make a small technical amendment.
I believe the patron regards that as a friendly amendment. May I hear a motion?
Move the amendment.
It's been moved and seconded to make that clarification. All those in favor say aye. Aye. Opposed? Are there any other comments? Then Delegate Simon, you have the final word.
Yeah, thank you all for hearing this bill again. I appreciate the concerns of those that spoke. I think that this strikes the right balance, and I do think this really is about preserving people's dignity even after they've passed. And I don't, I hear the concerns, I just don't share them with the folks that spoke in opposition. I think this does a great good for the Commonwealth.
Thank you. It's been moved and seconded. Report is amended. Are there comments on the motion? Hearing none, please open the roll. And members, cast your vote on HB 43 as amended. I'll close the roll. HB 43 as amended is reported by a vote of 7-3. Thank you, Delegate.
Thank you, Madam Chair. Thank you, members of the subcommittee.
And now I believe we have before us, we have three-member bills or two-member bills, but first one is HB 172. Delegate Mehta, would you like to present, please?
Thank you, Madam Chair and members of the subcommittee. I'm here to speak on HB 172. I understand that there are some substitutes, line amendments. Thank you.
Move the amendments. They have been distributed. Thank you. Please
Yes, Madam Chair,
report.
members of the subcommittee, these have been distributed. They should be posted online. These were small amendments that affect lines 18 and 24 and a little bit of 25 to refer to the current law and what's being added to say that they could inform the potential jury on the potential punishment or ranges of punishments instead of just the potential range of punishments.
Move the amendments. It's been moved and seconded. Any questions, comments? All those in favor say aye.
Aye.
Opposed? Please proceed.
Thank you, Madam Chair. HB 172 is a straightforward clarification that promotes fairness and transparency in Virginia's criminal justice system. This bill corrects a misinterpretation from a 2020 law and ensures that a person accused of a crime may withdraw a request for jury sentencing at any time before sentencing has begun, and it also allows both parties to question prospective jurors regarding potential punishment and sentencing. This bill will allow jurors to be informed about sentencing ranges, enabling more informed and just decisions. I ask that you report the bill.
Thank you. Are there any questions of the patron? Counsel? Hearing no questions, then I think we are ready for testimony. All those who would like to speak in favor of HB 172, please come forward. I see two individuals. If you could split 3 minutes.
Brad Haywood again for Justice Forward, Virginia. Just wanted to give the committee an example of when this change might come into play or why it's needed. So currently, defendants have a choice when they're facing trial on a felony, or either felony or a misdemeanor, about whether to have a judge sentence them or a jury sentence them. They have to give notice, 30 days notice if they want a jury to sentence them. And they do that based on what they're charged with. They think what they're charged with, and they say, what are the penalties I'm facing? What kind of case is this? And based on those number of factors, they decide either judge or jury. But the reality is that charge can change. It can change within 30 days of trial. It also can change during trial. It can change when there's a verdict that comes back. And when it does, that changes the calculus. So that decision that is made 30 days in advance can't be reconsidered and based on the new factors and the actual crime that the person's convicted of. An example of where this would be important is if, say, somebody is charged with distribution of drugs. Say it's a very minor case. It's somebody using cocaine with a friend. They shared it. They think that the jury will find them not guilty of the distribution and only of the simple possession. Distribution is punishable by 5 years to 40 years in prison. That means if you had a jury trial on that and you lost, the jury would have to impose 5 years. And the way judges work, they very rarely suspend jury sentences. You go into trial, you notice jury sentencing, but not because you want a jury on the possession with intent to distribute. You believe very strongly that your community and that jury is not going to convict them of possession with intent to distribute. And you believe that if they're convicted of simple possession, understanding in that community that it's viewed as a public health issue, that they're not going to impose prison time. You have a bad day in court, your client is convicted, or the defendant's convicted, and suddenly what they had thought would be the case, and they'd have a sentencing on simple possession, now they have a sentencing on possession with intent to distribute, and they're facing 5 to 40 years in prison, minimum 5 years for a very minor crime. That's an instance where that person ought to be able to say, you know what, change my mind. This doesn't prejudice the Commonwealth at all. They would have prepared for jury sentencing. And there's no real additional preparation they would have to do for a judge sentencing. It would just be continued, and that person would have the benefit of sentencing guidelines on the more serious offense. This just makes sense. I think it's closing a loophole that wasn't anticipated at the time mandatory jury sentencing was repealed. Thank you.
Thank you.
Good afternoon, Madam Chair, members of the committee. My name is Tim Coyne. I'm the Deputy Executive Director of the Virginia Indigent Defense Commission. I am not speaking on behalf of the IDC, but as somebody with 35 years of experience practicing primarily criminal defense. I'd echo all the comments that Mr. Haywood just made about the reasons for this bill. He's left me 10 seconds. But I would add that it's very important to remember that this doesn't prejudice the Commonwealth at all, because at the end of the day, the judge is the the court is the one who sentences the defendant, and they will have the opportunity to present any victim impact or other evidence at sentencing. So I would ask the committee to support this bill. Thank you.
Thank you. And is there anyone in the room wishing to speak against HB 172? One speaker, 2 minutes, please, when you come to the microphone.
I hope I don't need 2 minutes. My name is Clarissa Berry. I'm the Commonwealth Attorney in Madison County, and I'm here on behalf of VACA. Our largest concern with this bill is that it allows for a prosecutor or a defense attorney to ask questions about range of punishment in both guilt and innocence. And as you know, we have a bifurcated system here in Virginia, and so it's our position that if a jury's not going to be involved in the sentencing, then it's an inappropriate set of questions for them to be asked about in the guilt phase. Additionally, one of our second concern would be the impact that this can have on the victims of crime who are trying to ascertain, especially when you're talking about a child or a victim of a sexual assault, and whether or not they're going to be testifying in front of 12 strangers or testifying in front of a judge. They may prepare differently for that. I certainly understood and take to heart Mr. Haywood's arguments about how the crimes can change. That is true. A jury can come back with lesser includeds, but I would disagree that it is at no prejudice to the Commonwealth. When you prepare a case and you're going into it, you have to look at the whole thing. We're not, if you're driving a tractor trailer, you got to know what's in the trailer. And so that's what we're doing as well. And so there is an impact to the Commonwealth. We would ask the committee to consider that. Thank you.
Thank you. It's in line. We have 3 individuals who have signed up to speak. Dr. Mahonhaft.
Thank you, Chair Watts, members of the committee. Taj Manaf with the Humanization Project. Just fully in support of this bill because we know that jury sentences do not end up being the same as judicial sentences because of various aspects of the existing set of policies in Virginia, and we believe that anything to create equity and opportunity for people to be heard fairly is a good idea. Thank you.
Thank you. And then we have also an individual signed up to speak against, and that's Ann Tatis. Ann?
Yes. Thank you for having me this afternoon. I went through and I read thoroughly former Senator Morrissey's bill from 2020, and then I went through and I read the very strong in support of that bill, the statement from Justice Forward Virginia, and which they discussed judges versus bench trials, prosecutors and forcing plea agreements and all that. And I'll read directly from them. So what's the solution to this problem? Some have advocated for ending jury sentencing entirely, but juries are often the only thing standing between an accused and a pro-incarceration judge. In cases involving drug possession and property crimes, many juries give more thoughtful and lenient sentences than a judge would. Instead, the answer to this problem is giving the accused the option of whether to be sentenced by a judge or the jury in cases where the jury decides guilt. That is what the new legislation mandates. Delinking the jury verdict from arbitrary sentencing requires is a common sense reform that permits the accused to enjoy his jury trial right without facing a harsher sentence as a result. So after reading this and then reading that little line that the accused may withdraw such request for a jury to ascertain punishment up until the commencement of not of the guilt phase, the sentencing proceeding. So if the actual attempt is to be not decide whether you think both juries are going to convict you, because to have it up until the commencement of the sentencing proceeding versus, I agree with the 30 days being maybe a little problematic, but allowing it not up until you can change your sentencing up until change it to up until the end of the conviction phase if you see that it's not going your way. But you don't get rid of the 30 days. You don't jump from A to M without going through all of the other letters. Because what this ends up doing, if you can step and have some perspective, you're allowing people who have been convicted of crimes to decide what's going to suit them. And that's what I feel is that all of these laws is that we're letting criminals dictate their future. And it doesn't matter how radical, how liberal, how conservative you are, the impact that this will have on all communities is going to be so catastrophic, but we won't be able to measure it because nobody will actually be going to jail for anything anymore. And it alarms me for my children's future, my grandchildren, and it should do for all of you, no matter the color of our skin, no matter what our political beliefs, is the outcome of this is going to be people convicted of crimes choosing who's going to weigh out.
If you could wrap up, please.
Less lenient. I am, and I hope that all of you can have some common sense on this, and with that, I thank you.
Thank you. That is all the testimony I have before us. Are there questions of counsel or of the patron? I have one question of counsel, and that is, as I recall, when a juvenile is tried as an adult, the judge does the sentencing. Is that correct?
That's correct. By statute, if a juvenile is being tried as an adult on their first offense being tried by an adult, it's automatic judge sentencing by statute.
Do we need to have an amendment in this bill to preserve that?
The way I read the current language is that this would also apply to juveniles being tried in circuit court choosing to have a jury, that they would be able to voir dire on punishment regardless of whether they have the right to request jury sentencing. Because they don't, they would still be able to voir dire on punishment if that is the intent of the patron. That's how the language of the bill reads. Juveniles would be able to voir dire on that.
I need to have a discussion of why we shouldn't preserve that, why that reasoning in there as far as the full sentencing report, et cetera, that the judge would have, and the greater expansiveness that a judge in a juvenile case has in sentencing, why we wouldn't preserve that. If the patron could answer that, or if you want to call anybody else forward with background.
Perhaps Mr. Haywood would like to answer.
I think that point's well taken. I think the intent was mainly with adult defendants. So if that amendment were to be proposed, I don't think we would have any objection to that.
Thank you for that perspective. With that, if the council could report an amendment that would achieve that.
I guess from a language perspective, I'm confused at what we're trying to get at. Are we saying that the juvenile statute is still followed?
Notwithstanding, yeah.
Notwithstanding the juvenile statute, that you could still ask the judge or the jury about the sentencing, even though the statute says that the juvenile would get the judge sentencing.
I believe what I'm saying is I want to preserve the situation that occurs if a juvenile is tried as an adult, and I want to leave all of that alone in what is before us.
Okay. So we'll add something that says notwithstanding any other provision of law for juveniles.
Thank you. We operate by motion.
Move the amendment.
It's been moved and seconded that we are notwithstanding amendment as far as juvenile. All those in favor, say aye. Opposed? Aye. Okay. So that's as amended. Are there now other questions of the patron? You have the final, or are there comments from council, I guess, before we'll let the patron have the final word?
No further comments.
No, none other? Okay, you're on for the final word.
I just appreciate your time in this and your careful consideration, particularly, as I mentioned before, this is important for fairness and transparency in criminal justice system that we have here in Virginia. And I thank you, and I hope you report the bill.
Thank you, Delegate. Are there any comments, questions? We operate by motion. It's been amended even before my amendment, so there's several now.
Move to report substitute as amended.
Second. Was there a substitute?
It was a line amendment initially.
Move to report as amended.
Yeah. Thank
It's
you.
been moved and seconded that HB 172 be reported as amended. No further discussion?
Oh,
It'll be yeah,
Okay.
when we, okay, so a substitute, which will reflect the amendments. Somehow, maybe because we meet late in the day, we're a little flexibility here. So again, the motion before us is to report HB 172 as a substitute to reflect the amendments that we have adopted. Clerk, open the roll. Members, cast your vote. HB 172 reports as amended as a substitute, by a vote of 6-3.
thank you, Madam Chair.
Thank you. And now I believe the final bill on our docket is, if I'm correct, please correct me if I've missed. I think we've got two. We've got Delegate Cousins. You have HB 852.
Thank you, Madam Chair.
Please proceed.
Thank you. Also to the members of the subcommittee. HB 852 eliminates court-appointed attorneys' fees and trial by jury costs for indigent defendants. If a judge finds that a defendant is unable to pay for an attorney here in Virginia, the defendant is assigned an attorney by the court. However, the defendant is responsible for attorney's fees and jury costs related to the prosecution of the charges, despite a judge already finding that the person makes too little money to afford a lawyer. These fees can easily accumulate into thousands of dollars and in many cases account for more than half of an individual's overall court debt. Court-appointed attorneys' fees are notoriously expensive and inefficient for the Commonwealth to collect. And as such, they provide a very minor revenue source for Virginia. Over the past 5 fiscal years, just 3% of court-appointed attorneys' fees were collected in the same year they were assessed. At the end of each year, almost all court-appointed attorneys' fees remained as debt on the books against low-income Virginians. For some people, knowing this cost will be assessed means they will decline representation and enter the criminal legal system without counsel. This leads to wrongful convictions, longer sentences, and harsher punishments. These fees create unequal burdens for low-income communities and tie people down with a debt sentence, risking further entanglement with the criminal legal system. This bill does have a reenactment clause, which will give relevant stakeholders time to develop a comprehensive implementation plan. And the bill also asks stakeholders to report their findings to the governor and General Assembly by November 1st of this year. Thank you.
Are there any questions? Seeing none, at this point, I was brought to my attention by counsel that there's an inconsistency with the GAL statute. Is that a concern you wish to bring before us?
If that was the intent of the patron, I just looked at the GAL statute and it specifically only referenced indigent individuals who have been appointed to GAL for juvenile. But that seems to be the reflection of the intent to just apply it to indigent and not all people who are appointed to GAL.
Do you feel that needs to be addressed before the study, or it's something that could be addressed as far as the application of this bill? Should it be a?
I think it could be addressed after the study if there's any issue.
All right, okay. Thank you. Is there anyone in the room wishing to speak for HB 852? If you'd come forward. At this point, I see 1, 2, 3. Let's do a total of 5 minutes. If you could split it, please.
Great, thank you. Good afternoon, Madam Chair, committee members. I'm Pat Levy-Lavelle, an attorney with Legal Aid Justice Center. We support this bill. Why should Virginia eliminate fees for the exercise of constitutional rights? I'll speak to counsel fees first and then jury fees. As to counsel fees, people who can't afford to pay for their attorney can't pay for their attorney. These fees can add up to hundreds or thousands of dollars, and they hurt families who are already struggling to keep up with basic living expenses. When folks don't pay, they get dinged with interest and collections fees, can have probation extended, and even face further enforcement actions involving additional fines or even jail time. All of that is counterproductive for a system that should seek to promote rehabilitation and reduce recidivism. Second, this amounts to a regressive tax and one that has racially disproportionate consequences, according to JLARC. Public defense is essential, but it's not essential to fund the system in this way. As to jury fees, the Constitution guarantees defendants the right to a jury trial, but it's not a real right if you can't pay for it. In Virginia, under current practice, jury fees against a defendant can run into the thousands of dollars very quickly, as much as $2,000 for even a single day, even when defendants have no money. Others choose not to use their right to a jury because it's simply not affordable. In civil cases, no jury right exists, but in civil cases, people have access to a jury, and no one ever pays for using a jury in a civil case in Virginia, even when the litigants have deep pockets. This is totally backwards. The system needs to stop billing people who can't afford attorneys for their attorneys, and to stop billing people for juries in criminal cases. This bill recognizes that and establishes a work group to help plan for the elimination of these fees. We thank Delegate Cousins for bringing this important bill forward and ask the committee to support it. Thank you.
Thank you.
Madam Chair, members of the committee, my name is Kenneth Hunter. Formerly incarcerated, had early interactions with the justice system early in my life. These things last forever. They're crippling in a lot of cases. This gives an opportunity to deal with some of the collateral effects of being sentenced in the carceral system. An opportunity, hopefully, to serve your time and not be weighed down by additional fines and fees. So I just wanted to stand up and say I support this bill. Thank you.
Thank you.
Good afternoon, Madam Chair, members of the committee. My name is Cammie Blatt with the Commonwealth Institute. The right to counsel and the right to jury trial are constitutional rights. Yet in Virginia, individuals who have already been found indigent by a judge can still be charged these fees. Research also shows that these fees disproportionately impact Black and low-income Virginians. They generate only minor revenue for the Commonwealth and rely on payment from people who cannot afford to pay, often resulting in uncollectible debt that is costly for the state to pursue. Several states have eliminated fees for court-appointed counsel, and this legislation is a step towards a more fair system, and we ask that you support this bill. Thank you.
Thank you.
Justice Ford strongly supports the bill. Thank you.
Thank you. Is there anyone in the room wishing to speak in opposition to HB 852? Seeing no one, then online we have Dr. Mahad Haft from the Humanization Project.
Thank you, Chair Watts, members of the committee. For all of the aforementioned reasons, and because of the simple fact that nobody's financial situation gets better after they come home with a felony conviction, we should not be saddling people. The quickest way to keep people from thriving when they get home is to put things in front of them that create obstacles. We hope that you'll support this. Thank you.
Thank you. And again, the total time is 5 minutes if for those who are watching as you speak. Sheba Williams from No Left Turns.
Good afternoon, Chair Watts and committee. My name is Sheba Williams. I am the founder and executive director of No Left Turns. I am also an individual who was wrongfully convicted in 2004. At the time, I was a single mother with 3 children under the age of 5. I was in college. So not only did I have student loan debt, I encountered the 69,000 collateral consequences that greatly reduced my income and ability to pay back the fines that came along with my attorney, who was horrible, by the way. The wrongful conviction has impacted me for the past 22 years, and as a member of the Pretrial Justice Coalition, we support this bill not just because of my situation, but because of the thousands of individuals that we support in our direct service reentry work. Thank you.
Thank you. Valerie Slater from NAACP.
Yes, Valerie Slater, Director of Rise for Youth and the Criminal Justice Chair for the Virginia State Conference in AACP. And these fees, they function as a financial penalty for exercising constitutional rights. And it is particularly harmful when minors are involved because those costs associated with the indigent defense, it's going to fall to the families. And court debt can destabilize families. It diverts limited household resources. And, for those reasons we support, but also HB 852, it has a directive to convene a multi-stakeholder work group. And that is a responsible step that's going to allow the Commonwealth to examine current practices and understand the real world impact on families and plan for full elimination of fees by 2027, but without disrupting court operations. And so for all of these reasons, we support this bill. We really ought not fund the justice system by charging families for their children's constitutional right. Please pass this bill.
Emily King from Fines and Fees Justice Center.
Good afternoon, Madam Chair and members of the subcommittee. My name is Emily King and I am representing the Fines and Fees Justice Center. We are a national organization dedicated to working with communities, justice system stakeholders, and legislators to eliminate fees in the legal system and ensure that fines are equitably imposed. We're proud to voice our strong support today for HB 852. As noted, this bill eliminates counsel fees and jury fees, restoring for all what has become financially inaccessible for far too many, access to the constitutional protections guaranteed to every American. For too long, Virginia has treated these rights as services with a price tag attached, charging people for fees to access a public defender or a jury of their peers. But the safeguards of justice should not require a membership fee, and the Sixth Amendment is not a luxury item. It's time we stop treating our constitutional protections like a user fee system and start treating them like the bedrock rights that they are. HB 852 is a straightforward, common sense solution, and by eliminating counsel fees and jury fees, we are removing that paywall to justice. We are putting money back into the local economy and relieving the burden on working families. This legislation highlights the shared understanding that constitutional rights are not commodities to be bought and sold, and the Fines and Fees Justice Center wholeheartedly encourages its passage. Thank you.
Thank you. And finally, Dominique Martin from New Virginia Majority.
Good afternoon, Madam Chair, members of the committee. Dominique Martin, Virginia Majority, and for the myriad of reasons you've just previously heard, we also support the bill.
Thank you. And then also, if there are any questions, we have Eileen Londecker from the Office of the Executive Secretary.
Thank you, Madam Chair. We have no position on the bill, just wanted to be available if there were amendments or questions. Thank you.
Are there any questions of the office? All right. Are there any questions of the patron before the final word or any comment? I see we have Delegate Williams. Delegate Williams.
Yes, Madam Chair. Comment for the patron. Just like Delegate Simon, Bill, I'd love to see the study beforehand. But to what Delegate Watts said too, I understand how you could, prioritize it through this type of legislation. Thank you.
Thank you.
Thank you. Are there any comments that we should be aware of from council? Concerns? Okay. Hearing none?
No.
Does this have to go to appropriations? I don't think, yes, I do have to report and refer. There are no amendments before us, however, on the bill as I recall.
Move to report and refer to appropriations.
Second.
It's been moved and seconded that HB 852 be reported and referred to appropriations. Any further discussion? Although, clerk, please open the roll. Members, cast your vote. The motion, please close the roll. The motion to report and refer to appropriations passes by a vote of 7-3. Thank you. And now the final bill on the agenda is HB 1298, Delegate Delaney.
All right, last bill, Madam Chair and committee. So House Bill 1298. I do have an amendment. A substitute? It's a substitute.
Yes, Madam Chair, members of the subcommittee. Delegate Watts has we have prepared a substitute for Delegate Watts. It's been distributed and posted online. This substitute conforms the bill to the introduced version of the companion bill in the Senate, SB 748. The differences between the introduced version and the substitute is that it adds a definition of official documentation, and it adds a new subsection F in 19.2-327.18.
I'm sorry, I was distracted. This is a line amendment substitute that has been proposed. It's been moved and seconded that we adopt the substitute as reported. All those in favor say aye. Opposed? It's before us.
So, Madam Chair and Committee, the substitute before you is granting a rebuttable presumption to victims of human trafficking for an offense if there is an official documentation of the petitioner's status of victim of human trafficking at the time of the offense. So this amendment is necessary, or the substitute is necessary, as currently, even if a person is pronounced a victim in a criminal case of human trafficking, the Commonwealth may challenge the element of victim determination in the vacatur petition. So that's the reason for the substitute, but I'm happy to present the rest of the bill at the appropriate time.
Thank you. Are there any questions of the patron? Any concerns? Hearing none, we have a significant list online.
Madam Chair, that was actually just the substitute portion, but I'm happy to, I'd like to present what the rest of the bill does. That was just for the portion that Council determined, but I know we have a lot of people, so I will be quick. So the bill before you, the current vacatur statute provides critical relief to trafficking survivors by allowing certain convictions tied to their victimization to be set aside, but it is limited in range. In practice, traffickers routinely force, manipulate, and threaten victims into committing a wide array of criminal acts as a means of control. Recently, 21 survivors of human trafficking presented over 100 different criminal code sections that were directly connected to their trafficking victimization. These cases highlight a significant gap in existing law. So the solution that this bill brings before you is to expand current vacatur statute to cover all misdemeanors and all non-violent felonies committed as a direct result of trafficking victimization. This bill recognizes that traffickers coerce victims into a wide range of criminal activity that cannot be predicted or listed completely in statute. Importantly, this bill preserves all existing state safeguards and judicial standards already built into the current law, ensuring that relief is granted only when a clear link to the trafficker is established and to the trafficking event. It simply expands the list of convictions that these safeguards will need to be applied to. So by expanding the vacatur statute, this bill removes unjust criminal record barriers that prevent survivors from accessing employment, housing, education, and long-term stability, supporting meaningful reintegration and empowering survivors as they rebuild their lives. And that is the bill, Madam Chair.
Thank you. Now, are there, yes, I see Delegate Davis. Delegate Davis.
Thank you, Madam Chair. A question for the patron. So it eliminates all misdemeanors?
All misdemeanors and all nonviolent felonies, Madam Chair.
Okay. And would that include distribution of controlled substances?
Madam Chair, it would. These are common crimes that traffickers do coerce and force their victims to participate in.
Follow up, Madam Chair.
Yes, please.
Would it also involve a conviction for involuntary manslaughter if they're drunk and kill somebody?
We'll ask counsel to confirm.
It does not include things that are violent felonies under 17.1-805. I think involuntary manslaughter is a violent felony under 17.1-805, but I'm just trying to confirm. It's 18.2-36. I'm not seeing it now. So involuntary manslaughter would not be included, but there is a requirement that the involuntary manslaughter or whatever charge it was is directly related to the human trafficking. So that is a requirement in the vacator statute, that they have to file under petition that the charge, it's a proximate cause of the human trafficking.
Thank you, counsel.
With that clarification, are there any other questions of counsel, of the patron? Counsel, any other issues before we turn to the testimony? I know I do it wouldn't either way. If not, then let us begin with the testimony. Anyone in the room who wishes to speak on behalf of HB 1298, I see 3 individuals. If you could split 4 minutes, that would be appreciated.
Good afternoon, Madam Chair and members of the subcommittee. Thank you for the opportunity to testify in support of House Bill 1298. My name is Sydney McCoy. I'm the Director of Advocacy with Shared Hope International, a nonprofit organization dedicated to preventing and restoring the lives of individuals who've been impacted by child and youth sex trafficking. Virginia's existing vacator statute is an important acknowledgement that survivors of human trafficking should not carry lifelong criminal records for acts committed as a result of their exploitation. However, the law is currently too narrow. House Bill 1298 corrects this problem by allowing vacator for all nonviolent offenses when a survivor can show that the offense was a direct result of being trafficked. This approach on causation rather than the offense labels aligns with national best practices and avoids arbitrary distinctions that undermine the purpose of vacator statutes. And as a final note, I just want to say that the Trafficking Survivors Relief Act was essentially the same version of this, was just passed at the federal level. It was a bipartisan effort and was signed by the president like a week ago. So this not only is an important bill that's happening at the national level, but I think that it should be passed here. So I ask all of you to support this bill. Thank you.
Robert Boris, on behalf of the Virginia Coalition Against Human Trafficking. We strongly support the bill, including the amendments that came today. The one thing I would like to note, vacature still requires survivors to provide to the court that offenses were the result of being trafficked. In every case, the Commonwealth's Attorney's Office has the right to present their perspective to the court. We believe this process will ensure that all parties will get a fair hearing on this expanded list of eligible crimes.
Thank you.
Good afternoon, Madam Chair, members of the committee. Sean Winetto speaking on behalf of My Own Image, national nonprofit seeking to protect people from victims of image-based sexual abuse. We do support the bill and ask you to report it. Thank you.
Kate Hanger, I'm the Executive Director of the Virginia Victim Assistance Network, and we support the bill.
Thank you. Is there anyone in the room wishing to speak in opposition to 1298?
Good morning, or good afternoon, rather. Anton Bell, Commonwealth Attorney for the City of Hampton, representing VACA. We have a problem with the rebuttable presumption because at this point you place the burden on the Commonwealth to be able to show why or how this person was a trafficked victim. We understand that they have to bring in some type of verified information, but what is considered verified information? And so we have concerns about what will constitute sufficient evidence that this person was indeed a trafficked victim. In addition to that, I'm glad that I think it was Delegate Davis that brought up the point of involuntary manslaughter. That is not considered a violent crime under the Code of Virginia. As a result, that expansion of all misdemeanors and all nonviolent crimes is going to include drug distribution, and it's going to also include a form of homicide. We have an issue with that as well. Thank you.
Thank you. Then there are signed up online. I have a total of, I believe, 8-10 speakers, so please 1 minute apiece. And the first individual would be Lindsay Gray from Safe House Project.
Thank you for having me, you guys. My name is Lindsay Gray, and I am the Regional Operations Coordinator for Safe House Project, as well as serving at BCAT. I'm a certified human trafficking investigator, former EMT, and I am a survivor myself. So I'm here because I have worked kind of on both sides of the board, and I've seen on both sides of the board what it looks like. Unfortunately, we know that human trafficking is identified at a 1% ratio, and we know that it is tied to drugs, the drug criminal empire, and is only second to drugs, which means that we do see them tied frequently and that's really unfortunate. And what we're trying to work here is to eliminate and remove the crimes that are tied to people who are not directly going to increase and continue that behavior when they are removed out of trafficking, right? We want to prosecute the people who are committing the crimes on purpose and who are and intending to commit the crimes versus people who are being forced into situations that they have to commit the crimes to survive.
Thank you.
Unfortunately, I've seen many cases. Thank you.
Our next speaker is Courtney Delegates from the Virginia Coalition Against Human Trafficking. Courtney? The next speaker, Courtney?
Hi, good afternoon. Hi, good afternoon, Madam Chair and members of the committee. My name is Courtney Delegates. I am a survivor leader and an elected member of the Board of Directors for the Virginia Coalition Against Human Trafficking. I am a survivor of child sex trafficking from my freshman year to my senior year. I am now former law enforcement combating this crime through advocacy. Many survivors were arrested because frontline responders lacked training to recognize trafficking indicators, and those arrests were because the traffickers controlled their very movements, decisions, and survival. These records do not reflect culpability, they reflect victimization. This bill is not leniency, it's accuracy. It acknowledges the reality of trafficking dynamics, aligns our system with survivor-informed best practices, and restores the very things traffickers steal: agency, opportunity, and dignity. Though Virginia allows for survivors to apply for governor's pardons, those are not sealed, and that keeps biases intact, meaning survivors applying for housing, employment,
If you could wrap up, please.
denied.
Thank you.
And those opportunities are denied out of bias, and survivors are prohibited the opportunity to be contributing members of society. I respectfully ask that the committee vote in favor. Thank you for your leadership and your commitment.
Thank you. And the next speaker is Sydney McCoy from Shared Hope International.
She was in person.
Okay. The next speaker then is Courtney Schwartz from Virginia Sexual Domestic Violence Action Alliance. Courtney?
Madam Chair and members of the committee. Yes, can you hear me? Okay. Madam Chair and members of the committee, Courtney Schwartz with the Virginia Sexual and Domestic Violence Action Alliance. We are grateful to Delegate Delaney for bringing this bill forward. In expanding the vacatur statute for victims of human trafficking, this bill recognizes that forced criminal acts are the result of coercion and abuse. In doing so, this bill treats human trafficking victims as victims rather than criminals. We wholeheartedly support this measure, and we urge the committee to report this bill. Thank you so much.
Thank you. And our next speaker is Patrick McKenna from Virginia Coalition Against Human Trafficking.
Good afternoon, Madam Speaker and members of the committee. Thank you for the opportunity to speak on this bill. I'm with the Virginia Coalition. I'm also an attorney that facilitates a nonprofit organization called Just Free International, providing free legal services to human trafficking survivors. I can tell you from experience handling in this area in the last 14 years that survivors are frequently made to commit crimes and from a legal perspective really do not have the criminal mindset for which they should face conviction. If they are not guilty of a misdemeanor, which we kind of recognized in a number of cases last year with specific enumerated misdemeanors, they're also not guilty of having the criminal mindset for the felony. And as it relates to the presumption, that language was added after the original bill we proposed to the delegates and senator that was mentioned earlier, because we have found that in jurisdictions, even when the survivor was specifically enumerated by a federal organization and cooperated in a criminal prosecution during the time in which your own criminal charges were had, the Commonwealth still forced a trial, even though they had that official documentation from two federal agencies and cooperated in a prosecution.
If you could wrap up, please.
So in this case, yes, happy to do so. So in light of that, we are asking the court to report this bill out favorably. Thank you.
Thank you. And the next speaker is Lauren Easton from the Center for Global Justice at Regent University School of Law. Lauren?
Hello. Yes, thank you, Madam Chair. Thank you. Committee. My name is Lauren Eason. I'm an attorney at Region at the Center for Global Justice. We operate a human trafficking clinic where we assist survivors with pro bono legal representation in vacatur relief. And I would like to ask respectfully that this bill.
We lost the audio. You asked respectfully that this bill be passed, I assume? All right. The next speaker is Fatima Wahid from speaking on her own behalf.
Madam Chair, Committee, I'm Fatima Mawahid with Survivors for Justice Reform. We are a survivor-led coalition dedicated to dismantling the systems that continue to punish us for crimes committed against us. For many, human trafficking is a clinical term, but for the survivors we represent, it was a period of sustained torture. Traffickers do not just employ people, they use physical violence, psychological terror, and the threat of starvation to break a human being's will, which causes them to do these crimes. Many of the survivors I stand with were subjected to ancillary crimes like trespassing, petty larceny, and missing a court date. When a survivor is forced to live in a state of constant survival, failing to appear in a court is often a result of being physically restrained or fearing for their life. We strongly support this bill, and we thank Delegate Delaney for putting it forth. Thank you.
Thank you. And the next speaker is Dr. Mahon Haft from the Humanization Project.
Thank you, Chair Watts. Sorry, I was having technical difficulties. The Humanization Project strongly supports this bill for all the aforementioned reasons, and because it is especially apt for women who are incarcerated. This is particularly common in that it's our largest demographic of incarcerated people growing in Virginia right now. Thank you.
Thank you. And finally, we have, we have two others. Sheba Williams from No Left Turns.
Thank you, Madam Chair and Committee. Sheba Williams with No Left Turns. We support the bill, and we'll be brief because we've had a ton of speakers. Thank you.
Thank you. And then we have Valerie Slater from Rise for Youth, NAACP.
Yes, thank you, Chair Watts, members of the committee, and we thank you, Delegate Delaney, for bringing forward this bill. You know what? This legislation, it's going to be particularly important for minors and their families because many children who are victims of human trafficking have criminal offenses that are a direct result of their exploitation. And these are the records that this bill seeks to vacate. The legal consequences can be devastating and counterproductive. So expanding vacatur, it helps to ensure that the justice system doesn't continue to punish children for harm done to them, and it supports a trauma-informed, victim-centered approach consistent with youth justice best practices. So for minors, clearing these records is critical to rehabilitation and long-term stability. For families, vacatur can remove significant legal and financial barriers that impede healing and recovery. And HB 1298, it strengthens Virginia's commitment to protecting victims of human trafficking and aligning with broader youth justice reform efforts that prioritize accountability for exploiters and not for the children who have been exploited. Please support this bill.
Thank you. And then we also have online, if there are any questions, the representative of the Office of the Executive Secretary, Eileen Longdecker. Are there any?
Thank you, Madam Chair. We have no position on the bill.
Are there any questions of the Office of the Executive Secretary? Seeing none, that concludes the testimony. Are there comments of council?
I just wanted to clarify for Delegate Davis. I had to go through 17.1-805 that carves out all the violent felonies in Virginia. Aggravated involuntary manslaughter would be a bar. So if regular involuntary manslaughter is not classified, but aggravated would be. So if someone was grossly intoxicated and killed someone, that would not be. But either way, it still has to be the proximate cause, and they still have to be a victim of human trafficking at the time they were arrested. But I just wanted to clarify.
Thank you. Delegate Williams.
Yes, Madam Chair, a question for council. The burden remains on the victim to prove by preponderance preponderance of the evidence. There's no shifting to the Commonwealth, is there?
So that's correct. The burden remains on the petitioner. There is now a subsection that would say there is a rebuttable presumption. That would be Section F of 19.2-327.
127 through 129.
Yes, and it would say there shall be a rebuttable presumption that a person's participation in an offense was a result of having been a victim of human trafficking if there is official documentation of the petitioner's status as a victim of human trafficking at the time of the offense. So that is an amendment. So originally the burden is still on the petitioner, but if they're able to provide that official documentation, and the amendment also defines official documentation, so that would be defined by the amendment as well. It means any documentation issued by a federal, state, or local agency tending to show a person's status as a victim of human trafficking. So if they're issued that official documentation, then it does become a rebuttable presumption.
Any follow-up? All right, seeing no one else wishing to speak, you have the final word.
Thank you, Madam Chair. And so, just to reemphasize what we just heard, I do want to just make sure, since it was part of the opposition to the bill, that the reason why we added the rebuttable presumption, one, that it is narrowed to a scenario where there already is documentation, not for all cases. That burden of proof by preponderance of evidence would still be in place for everyone else. But if someone has already been deemed a victim by a government official or through a previous court, and that documentation already exists, that would be the area where the rebuttable presumption would be in effect, and that is based on what we've seen happen. We've heard from advocates that Commonwealth's attorneys are challenging victim statuses even when there is evidence that survivor has been screened and determined to be a victim by a government official. So we're seeing that barrier to them accessing this remedy, and that's the reason for putting that in, is because those practices that have been reported by our advocates are taking place. And then, otherwise it is the preponderance of evidence for everyone else that hasn't met that criteria, and that, Commonwealth's attorneys would still participate in those proceedings. But in closing, Madam Chair, I think just to note, as you heard from many of the advocates, what trafficking really looks like. These are people who are forced and coerced to really engage beyond, the scope of what someone might typically think of with trafficking. Might be prostitution, could be labor trafficking. Oftentimes, in the sense of sex trafficking, we see pimps will intentionally use victims for some of these other financial crimes, drug crimes. These are the common remedies that many survivors need. In 2020, we passed the narrow version of vacatur. That was my bill then, that did narrow it to the prostitution charges. I've heard at last report, there may be more, but it was sometime last year that 3 survivors of trafficking had benefited from that remedy, which is great. But what I've heard from survivors is it's the drug charges that he made me do that is my barrier to recovery and my barrier to move on from that life. So once someone is able to break free from these trafficking scenarios, those pimps are making sure that they are held back by making sure that they are the ones who take the fall for the crimes that the traffickers are forcing them to engage in to advance their business. And that'll be where I'll leave it for the committee. I hope you'll pass the bill.
Thank you. Okay, it's moved and seconded to report as substitute. Is there any discussion? Clerk, please open the roll. Members, cast your vote. Okay, it has been. Okay. It is please close the roll. HB 1298 reports unanimously with substitute by a vote of 10-0. And I believe that it concludes our docket. Everyone drive safe. Hope you get back here safe as well.